A police officer may legally and falsely tell a suspect, hey, your friend already confessed, or we found your fingerprints, or we have witnesses, or even you're not a suspect. And in many situations, courts have allowed statements obtained from suspects after those kinds of tactics. Most people assume that if police use deception during an interrogation, that the confession automatically gets thrown out. That is not usually how the law works, because interrogation law is generally not centered on whether police used deception in the abstract. Courts usually ask a different question. Did the official coercion become so powerful that it overbore the suspect's will under the totality of the circumstances? And once you understand that distinction, interrogation law starts looking very different. Hi, I'm Joel Chorny, a criminal defense attorney here in Arizona, and today I want to walk you through what the law actually says about deceptive interrogation tactics, where courts tend to draw constitutional limits, and why false confessions are a much bigger issue than most people realize. And before we start, let me just say that this is not legal advice for your specific case. Laws vary by jurisdiction, facts matter enormously, and if you're under investigation or facing charges, you should speak directly with a lawyer that is licensed in your state. One of the foundational Supreme Court cases here is Frazier v. Cupp. In that case, police falsely told their suspect that his cousin had already confessed. That statement was false, but the Supreme Court still upheld the admissibility of the confession. Now, the court treated the deception as one factor within the broader voluntariness analysis under the totality of the circumstances. And that phrase matters, totality of the circumstances, because courts often do not ask, did the police lie? They ask, did the interrogation tactics become so coercive that the suspect's will was overborne? That is a much narrower constitutional inquiry than most people assume, and it means that deception alone frequently does not result in suppression. A lot of people hear this and immediately think, well, wait a minute, doesn't Miranda prohibit this? Not exactly. Miranda v. Arizona was primarily focused on compulsion and the need for procedural safeguards during custodial interrogation, not on creating a general prohibition against interrogation deception. At the same time, Miranda repeatedly acknowledged the inherently coercive pressures built into the custodial interrogation itself. The court described custodial interrogation as creating inherently compelling pressures, and the Miranda warnings were designed to help counterbalance those pressures: the right to remain silent, the right to counsel, the warning that statements may be used against you. But Miranda did not establish a simple rule that deception automatically makes a confession inadmissible. And one thing that often confuses people is that Miranda issues, voluntariness issues, and suppression issues are related doctrines, but they are not always the same thing. So what is the actual constitutional framework? Well, the central issue is usually voluntariness. Courts ask whether official coercion overbore the suspect's will under the totality of the circumstances. That analysis can include factors like age, intelligence, intoxication, exhaustion, isolation, duration of questioning, psychological pressure, threats, promises, deception, access to counsel, and prior experience with law enforcement, just to name a few. And courts evaluate those factors together rather than through a single bright line rule. Another major Supreme Court case here is Colorado v. Connolly. That case emphasized that coercive police activity is generally required before a confession will be considered involuntary under the Due Process Clause. That distinction matters tremendously because the legal system is often focused less on whether a statement was reliable in the abstract and more on whether official conduct crossed constitutional lines. Think about that. Not whether or not the statement was reliable, but whether or not the police overstepped in getting the statement. Those are not always the same question, and that surprises a lot of people. And this is not just old Supreme Court doctrine from decades ago. Courts still routinely apply this framework today. Take, for example, Commonwealth v. Foster, a Pennsylvania case from 2025. In that case, police told the man that he was not a suspect, even though investigators already viewed him as a suspect and had obtained a DNA warrant connected to the investigation. In that case, the Pennsylvania Supreme Court rejected a per se rule that the deception automatically rendered the statement involuntary, and instead applied the traditional totality of the circumstances analysis. That theme comes up repeatedly in interrogation law. Courts often tolerate some degree of deception or subterfuge unless, in context, the tactics become coercive enough to overbear the suspect's will. And mind you, it's the courts who decide if it was enough. You better believe that they will do what they can to find that it wasn't. Which means that people should be very cautious about assuming, hey, if the police tricked me, the statement can't be used. Nuh-uh. That is a very dangerous assumption. But this does not mean anything goes. There are, thankfully, constitutional limits, and one of the strongest examples is People v. Thomas, a New York case from 2014. This case involved the interrogation of a father whose infant son had suffered catastrophic injuries. According to the New York Court of Appeals, the interrogation involved a combination of false assurances, emotional exploitation, repeated deception, and psychologically coercive tactics. Investigators repeatedly suggested that if the father explained what happened, doctors might still be able to help the child. They repeatedly characterized the injuries as an accident, and they repeatedly implied that cooperation could help him. The court ultimately concluded that the tactics used during the interrogation rendered the confession involuntary, and this part is extremely important. The issue is not simply whether the investigators lied. The issue is whether the combination of tactics became so coercive that the defendant's will was overborne and the interrogation created a substantial risk of false incrimination. That is a very different inquiry, because interrogation law is not really divided into truth versus lies. It is much more focused on coercion, voluntariness, and constitutional limits on psychological pressure. This is also where false confession research becomes critically important, because many people instinctively believe, hey, an innocent person would never confess. And that is simply not true. Psychologically manipulative interrogations can create panic, hopelessness, exhaustion, confusion, distorted thinking, and perceived inevitability, especially when combined with long interrogations, isolation, implied promises, false evidence claims, or emotional pressure. And this is one reason some states, particularly in the context of juvenile interrogations, have begun imposing stricter limits on deceptive interrogation tactics. Illinois is one of the clearest examples. That reflects growing concern about the relationship between psychologically coercive interrogation tactics and false confessions. So what is the takeaway from all of this? It is not that the police can do anything they want, and it is not that every confession is unreliable. The real takeaway is this. Do not assume that because an interrogation feels manipulative or deceptive, that a court will automatically suppress the statement later. Courts often permit more psychological pressure and deception during interrogations than most people realize. And once a statement exists, you may lose control of the situation much faster than you expected. The safest time to protect your rights is before the statement exists in the first place. So remember, exercise your right to remain silent and exercise your right to have an attorney present for all questioning. I'm Joel Chorny. You do have rights. They matter. You must protect them. Stay safe. I'll see you in the next video.